effect. So the answer to that is that, strictly speaking, you've got 6 months from the date of a grant of probate or administration being taken out from the probate registry to bring a claim. If you miss this important deadline, you can only bring a claim with court permission. There's a lot of case law kind of governing the question and circumstances of when the court will or will not grant permission. There are a number of very high-profile cases last year, including one where a widow was granted permission to bring a claim over 25 years out of time. The circumstances were very unusual, but what that does go to show is that the length of time isn't the only kind of determinative factor. I mean, very broadly, when the court are looking to give permission, they'll generally look at what are the reasons for the delay, and is there merit to the underlying claim. And it's also very important whether or not the estate's already been distributed, because if it hasn't, the court are more likely to grant permission, because as you could appreciate, if you've got a beneficiary who's already received their inheritance legitimately and spent it legitimately, the court will be much more reluctant to kind of force that person to pay back to the estate, because it will cause them potentially much more hardship and it will be really unfair on them. And I guess another thing to add is that it is possible to agree kind of a pause or an extension to the limitation deadline. This can be, an appropriate and sensible thing to do in some cases to save costs or avoid any escalation if the parties, are genuine about reaching an early agreement to save costs. But it's really important to be aware that those agreements, which are called standstill agreements, aren't binding on the court. And so, even though there's a small risk, the court could technically not give you permission even if an agreement has been reached. So that's something important to bear in mind. There was a high-profile case last year in which the court denied permission despite there being an agreement in place, although that's since been overturned, and the general kind of consensus now is that the agreements are good. But kind of pulling all that together, our advice to anybody thinking about a claim would be to seek advice and to act as quickly as possible, particularly if grant has already been taken out because the clock is ticking. If you become aware of a claim after the deadline's already passed, then the court may give you a bit of leeway if you weren't aware or you hadn't received advice, but they're going to be much more sympathetic as soon as you are aware and you receive advice. So then it really is important to act quickly and to issue the claim as quickly as possible.